All right. Well, people will keep coming in, but we want to start kicking things off. I just want to introduce our really amazing guests today. We're talking about something that is not talked about enough, given how important it is to edtech founders, to edtech investors, to education, highly regulated industry, lots of laws, lots of privacy issues, lots of things to think about, lots of contracts. And we want to make sure that the community feels supported and that you know some really core things that are important to know about how edtech companies should do legal. So we have with us today Evan Hill-Reese. He's a former deputy counsel of Amplify for almost a decade, and Naomi May, senior counsel for special counsel, right? Is special counsel? Sorry, special counsel at Cooley, who focuses on education as one of the core use cases. They are really amazing. They've been giving us their time today. I see Tomek Gross joining as a guest. Welcome, Tomek. See you. It's great to see you all. Let's get started. As we go, please feel free to put questions and thoughts in the chat. At points, the guests will answer questions in time. We will also have a Q&A period at the end. So if there's something you're thinking about as they talk and you want to hold it for the end, you can do that as well. Learnosity, San Diego, terrific. Answer the poll. I'm going to share the results of the poll right now, just so we can look at it a little bit. It looks like across the board, people are thinking a lot about financing and fundraising, compliance and data privacy, no surprise. Intellectual property is up there, and liability, cost, all across the board. Everybody has a number of different things, but yeah, these are big ones. All right, with that, let me kick it to Evan to kick us off and talk about how edtech companies should do legal.
Thanks so much, Alex. And thank you all for joining us today for this conversation. I'm hoping you all get something you need out of it. And I hope we have a chance to answer some of your questions at the end. So we'll make sure to leave time for that. And please do bring us sort of what's top of mind for you. What, if any, questions these slides provoke for you. So, other title slide. Sorry, that's duplicative. But what we want to cover here is really just to answer a few questions that, if you're showing up for this presentation, I want to say it's probably a safe bet that you've wondered about at least the first couple up here. Lawyers seem like sometimes they're everywhere, but I'm actually here to try to make the pitch to you that you might not be thinking about what lawyers can do sort of broadly enough. And so we'll go through some of these questions to make sure we build the foundation for helping you broaden your thinking on this question. So to start, why does your edtech company need lawyers? It's not just for forming the company, and staying out of jail is nice, but let's set the bar a little higher. Let's do more than not go to jail. I think you as business leaders in this space need to evaluate and manage a lot of different risks. And legal risks are one of those buckets. So I think I want to bucket them out for you in the way that a lot of auditors and others will look at them when they're evaluating your company. So I want to see if we can set your mindset towards thinking about at least these categories and how they might be something you should be paying attention to, having a strategy for when you think about how you build your company and position it really well for growth. So starting with compliance risks, again, a lot of these are a little self-evident in the obvious case. Compliance risk is about the risk of not meeting the requirements of existing, new, or modified regulations. But it's not quite just that on-paper risk, right? There's also the risk of changes in regulator focus, from political changes or the growth of an agency, and about the fines and penalties imposed by the regulator. So when I say that there's often some uncertainty about what the regulations require, also mean that there's some uncertainty about if or how a given regulator might enforce a regulation. So you need to have some way of getting your arms around quantifying those risks. What does that really mean to say that we might have a compliance issue here it's a multi-factor determination. It is not just, oh, well, if I just go read the reg, I'll know instantly as a binary thing whether we are or aren't compliant. It is unfortunately rarely that easy. Uh, so contract risks are the risk that the company will fail to keep track of and meet or enforce its contractual obligations or rights, or enter into contracts with terms that are either inadequate, unfair, or unenforceable. And I'm reading you guys the definitions of these things because I think it's helpful to understand sort of what the starting point is for somebody who's using these kind of risk frameworks to look at your business. And note that that one is not just about bad contractual language. It's not just about having struck a bad deal that you regret. It is also about how you keep track of what you owe and what you're owed under the whole universe of your agreements. So this is about knowing and not losing track of as an organization, as people leave, as people join, what you actually need to do and what you've already committed to do under your existing agreements. Next is the rights risk. And I think a lot of you will jump to the obvious IP rights at issue. And those are obviously a big part of this bucket of risks. So absolutely worry about copyright, trademarks, patents, trade secrets, but also generally think about what are third parties entitled to that are outside of any contracts you may have with them. This is not about the deals you may have made. This is about rights that people have been given by statutes, regulations, constitutions, right? So think about it as in the EdTech space, your IP rights, but also often very salient is what rights do you have to the data you've collected? What can you do with the data you've collected via the use of your products? And where are you restricted in that way? And what rights might those so-called data subjects have, either to get that data altered or corrected or simply disclosed to them? Those are all things that you need to understand, and if you're required to, build processes around. Okay, dispute risks. This is, like it says on the tin, mostly about the risk of being sued or having to sue. Those are the big ticket items when you think about disputes. But I think in the EdTech sector, it's definitely broader because you are in sales processes that involve RFPs. Your customers, schools and districts, run these RFPs, and those RFPs tend to have broad disclosure requirements. So the risk of a given dispute cannot just be, oh, we might spend a lot of money dealing with this dispute, we might get a negative result at the end of it, but it is also the risk of having to tell almost every customer about it for the next bundle of years. And that can be significant because if you think about it, you're having to bring this sort of painful fact up in competitive procurement processes for up to 10 years, I've seen in some areas. And so that can be a real reason to try and resolve things amicably. It can be a real thumb on the scale for figuring out how to get to a posture where this is not a dispute that you end up having to talk about for the rest of your life, if you will. Next, we have reputational risks. And again, this is broad. This is covered in other parts of your org. There are other people in your company who care about this. Marketing cares about it. Comms cares about it. The executive team cares about your reputation, obviously. But one niche here, in terms of things that legal sees and can help with, is how the company's approach to its legal obligations, its legal needs, can get interpreted by non-legal audiences. So the classic example here is the idea of like aggressive tax avoidance. So they may, a company may be very well within the letter of the law and how they structure themselves to minimize their tax burden. But you also see plenty of reputational hits they take when people in general start feeling like they're not paying their fair share and they start getting raked over the coals in the press because of it. You can also see this in the occasional online freakout on social media about companies' terms and conditions and how, in particular, like the IP provision seems like it gives them these crazy broad rights to use your content however they want in any fashion, in any part of the universe. And I think as someone who has written those, I want to stand up for the fact that a lot of times you do need pretty broad rights to actually offer the service. This is social media. This is about showing things that some users have created to other users in all kinds of different places and all kinds of different screens. But I also want to allow for the hit that sometimes companies do not draft those provisions thoughtfully enough, and they don't think through this lens about how consumers are going to read that, how their users are going to interpret what they need to get, based on the language that they put in what is, by any admission, the fine print. It is not something that you think about as much as the sort of hero image on the homepage of your website or the sort of intro message when someone first signs up for the app, but it can get you into these kinds of risks, and they're worth considering. I think here you can also think about, when you have states and school districts as customers, you can sometimes be exposed to the collateral risks of what are essentially political fights. And here I think everybody probably has, if you're in any way in the business of providing content to schools in the instructional sense, you have had to deal with some kinds of the so-called anti-CRT complaints in the past few years, even in states that haven't passed specific anti-CRT bills, even in places where this isn't about a compliance risk of like, you can't have this in the curriculum because the law says so. This is about the risk of setting yourselves up in the wrong way for a fight at the school district meeting, at in the sort of Facebook groups for that town or that district, in a way that I think, if you don't think about it ahead of time, you can get into a bunch of footfalls there, even outside of looking at the actual regs on point and worrying about those. All right, so those are the buckets of legal risks, that I, like I said, like to broaden your view on, have you think a little more broadly about. But what should you be thinking about right now? I think, these webinars hopefully are always about giving you some sense of, what should I be doing tomorrow that I'm not doing today? What should shift? And here I encourage you to think about your company specific risks. So of that stuff that we just went through, what have you not buttoned up? What don't you feel like you have a good handle on in terms of your strategy, in terms of what you know about whether it's the regulatory landscape or even how your own company is handling its obligations? Where can you button it up better? But also, you need to be thinking, sorry, excuse me, you need to be thinking about general tech industry trends too. This is EdTech. We all sorts of things happen to the tech industry. Those things happen to EdTech as well, by and large. And so I saw a lot of you are worried about financing and fundraisings and the trends in fundraisings, and when capital is available for investment and under what terms is absolutely a risk that you should think about and try to see around the corners of, if you can. Where is that heading? When your runway is going to be done, what is the fundraising landscape likely to look like? That you should also be thinking here, obviously, about how disruptive innovations are going to affect what maneuvering ability you have in the market. Obviously, in the last couple of years, LLMs and other generative AI technologies have caused a lot of movement inside all of your companies. It has, I'm sure it has at least been something you feel like you have to think about. And I think it should still be part of how you think about the risks that are coming along with, as those technologies develop. You've seen a lot of attempts to regulate it. And that leads into the other bucket I'd like you to think about, which is just regulatory trends and risks. What, outside of your control of what you're doing in your company, what may happen to you? Because now it is time for California to take an interest and pass any number of AI bills. I think I saw that they've passed, I want to say, 60 things that are related to AI, maybe not full-blown AI bills, in the past couple of years. And I don't expect that to slow down right now. I think I expect that to see that across more states. But thankfully, we have our most expert outside counsel, Naomi, here from Cooley, to talk about those kinds of risks. So I'm going to kick it over to her in a minute to cover those. But first, I want to stop for a second and try to poke some holes in what you guys may be thinking about why you don't need lawyers yet. Because I think over the years, I have heard a lot of things in these veins, that I think I want to make sure you understand why from the lawyer's perspective, those aren't going to be good enough answers, and I want to see if I can convince you that they're not. So we can avoid a lot of bad things without expert advice. Like, this is true. Your product teams probably know that they shouldn't build some kind of murder bot, hopefully. And they will have intuitions about almost everything that they're doing, which range from, well, this seems fair, like I'm a good person trying to do good things for my users, to this must be allowed. We must be allowed to do this thing because this other company in our space is doing it. And those can be really super helpful data points. Like, I don't want to gainsay those. We should know about those. Understanding the experience of other players in the market is crucial in thinking about your risks. They aren't, those data points aren't often the whole answer. And I think using them as heuristics to make decisions can accumulate a lot of risk debt, like technical debt, that you don't always see. You start saying, you have made the right decision because you did the same thing this other company was doing, but you don't have the perfect insight and vision into how that company got to the decision to do that thing. So the company you're copying has done the thing you can see on the surface, but what have they done underneath the surface in terms of compliance processes to make them comfortable doing it that way? And if you're going to just copy that surface layer, you are maybe setting yourself up for something you don't realize is a risk. Next, we have the more general idea of people will come to you, or you will think that you just have some good faith arguments about why we're doing a good thing here. This is the right thing for users. I think we can often, in the EdTech space, say, like, this is good for students. And that's obviously the guiding light. That should be the North Star for what we're trying to do. But I don't think you should be giving yourself too much comfort, because honestly, most of the time, you don't want to need those arguments. If you find yourself in a posture where you're actually needing to make these arguments, you are often already into the bad process, whether it's a regulatory inquiry or a school's compliance monitoring, or even like a lawsuit from a competitor. So what I want to do here is push back on the idea that it's enough to have an argument that you think you could win in court with, that you think if it ever came down to it, you could convince a judge that you're doing the right thing and you're within the law. I think that's too low a bar, right? Let's try not to get to that point. And the third thing I want to push on here, sorry, somebody have a question? Okay. The third one I want to push on here is just ultimately whether or not to take a risk is often a business decision. And if you collapse all risks into a business decision, I'm worried that you might not be using the right heuristics to make each of those individual decisions. So of course, you think about this all day long. You have execution risk. Can your team actually build the thing you've envisioned? You have market risk, like, will your product work, look, or feel better than the other options your users have? Legal risks, I think, are here about what some other people will think about what you've done, similar maybe to your users. But the problem here is that you can't often sort of A/B your test out of your way out of resolving a legal risk. Your users feeling like a feature is useful or not, it's just not the same thing as a regulator feeling like your product is compliant or not. So your way of resolving risks, of making decisions, needs to be a little more expansive if you want to put legal risks into that bucket, if you want to run them through that heuristic. And I think having access to good lawyers is really the right way to do that. And so with that, I'll hand it over to Naomi to talk about how you guys navigate what is a highly regulated industry.
Hi, everyone. So great to be here. As Evan has emphasized throughout his remarks today, there is a lot that makes EdTech unique. And legal issues in the space are no exception. So when we talk about these issues, I do always like to start with the why. All of this we know, but it's helpful to refresh our memory as we think about this complex web of requirements. So first, I mean, why do the reputational risks tend to be higher in this space? In part, that's because of the impactful nature of what you're selling. In part, it is because of you are processing children's data. You're processing sensitive information. It's also important because superintendents talk to each other. And at the end of the day, it's a small world. And the sales process is its own beast, not least because for many EdTech companies, your primary customers are essentially government agencies. Diligence in a financing might focus on issues that other tech companies don't have to think about for all of these reasons. So these are some of the reasons why it's a highly regulated industry. So how do we take it kind of from vague, this complex web, to specific, right? One of the first questions we always ask when we're thinking about what laws apply in any given situation is, what is direct regulation? So for example, there are some children's and students' data privacy laws that apply directly to you as a provider of online services, for example. But some of the regulation flows through to your customers. So for example, state law might dictate what SEAs and what LEAs have in their contracts with you. If you sell to higher ed institutions, federal student aid rules might limit how you perform your services, how you are paid, even how you pay your own employees as a third-party contractor. So within this complex web of federal, state, local, accreditor sometimes requirements, industry requirements, plus all the corresponding regulatory and enforcement agencies that go with all those laws, you don't have to worry about just the US Department of Education, but also the FTC, states attorneys general, sometimes the CFPB, state or federal education agencies, departments of labor, that's common in the workforce space. And then even within EdTech, different laws apply, depending whether you are in the early childhood space, in K-12, in post-secondary, workforce, sometimes all of the above. And the legal requirements will also be different depending on your business model, direct to consumer, B to school, even B2B, which is particularly common again in the workforce space. So thinking about this combination of laws, not all of them necessarily apply to you. And one of the things I see really commonly is assertions, we're compliant with X law, but actually it doesn't even apply to you. And understanding what applies is really important as a starting place. Because yes, it's complex, but when you boil it down, you look at your product, you look at your customers, that will dictate the framework within which you have to operate. And at the end of the day, when you're thinking about your legal needs, the question I'm also always asking as outside counsel is not just, how do you stay out of trouble, but really, how do you turn your knowledge of what applies to you into a strategic differentiator? Because really all these complex regulatory schemes, they don't really have to be the enemy of innovation. In fact, I have found that they can often really facilitate creativity because there is a reason why these laws exist, just like we started with. And when you understand why, and you can think about your product, your specific customers, and fit this together in a framework, that can often really produce good results for your clients and for your learners, the learners who are your users. With the right tools, you can use that to an advantage. So what could otherwise be a barrier to entry turns into a strategic advantage for you. So next slide. And I do understand, where do you even start? Because it's overwhelming. I like to break this down by thinking about how an EdTech company's legal needs tend to run in a cycle, both macro level, so company life cycle, founding to exit, but then also when you're thinking about each new product launch or innovation or strategic pivot or the addition of new features. So we start at the beginning and we say, okay, well, what is the legal framework when you're designing your product and services? What is the build? So recently, this has been a lot about generative AI products. So when I look at a generative AI product from a legal perspective, I ask a few core questions and boil it down. What are the inputs, right? What kind of information is being inputted? Is it protected from an IP perspective? Is it protected under any number of data laws, federal, state? Then I ask, what are the outputs? What are the risks? Does it matter who owns the outputs? Do I need an enterprise agreement with the LLM? Are base or API terms sufficient? And are there any regulatory requirements that limit, for example, how a school or university can use that output, such as whether it is sufficient to satisfy maybe state and accreditor requirements for distance education instruction? all of these questions really come together and focus on the build, the product. And then once we have that product conceptualized, then we turn to how do we protect? How do we protect this product that we have conceptualized or built? And for many ed tech companies, this starts with understanding with clarity all of your contractual relationships and how you connect to connect all of those to protect that product. So there are some that you have to consider even before you start building. So your contracts with every single independent contractor, every employee, every vendor, to make sure that you own all that IP. And then you think about licensing structures. You think about the associated risks with that. And these can look wildly different depending on your business model. When do your terms of service apply to users? Or when does your customer enterprise agreement govern? Does the privacy notice apply to all users? Or does it only apply to direct-to-consumer users or just visitors to your website, for example, for marketing purposes? And understanding with clarity is really helpful in protecting your product. And in EdTech specifically, the risk calculus can be a challenge here. And this is often because in part, many of your clients are public entities that won't agree to indemnify you for third-party claims, for example, or agree to limitation of liability. And even if they do agree, that doesn't mean it's going to be enforceable if push came to shove. So you have to factor that in on the front end. It can also be a challenge because your users are often children, right? So one of the big questions is always, who's consenting on their behalf? Is it the parent? Is it the school? Where are you sending notices? What is that flow? So you have to understand how the legal obligations and protections fit together and flow between all the parties. And then hopefully, once you have all that in place, will you be in a good position to defend against any threats or claims, investigations? And again, I know a broken record, but EdTech is a highly regulated industry. So sometimes enforcement actions can come from surprising sources. So for example, if you sell to colleges, the US Department of Ed might not regulate you directly. Sometimes they do, but most often they don't. But if a customer for whom you're performing recruiting or marketing services files a complaint with the department about what you've done, it's sent to your customer. And then what are you going to do about it? It's a bundle of considerations because it's not just about the specific legal issue. Like that's far too narrow. You know, for example, was it a misrepresentation of the program outcomes, for example? It's even more about the customer relationship and the ripple effect and your name on the department's radar. And all of that needs to be taken into account. And then to use another example, more and more we are seeing parents be more aggressive in testing the limits of children's and student data privacy laws. So there's not a private right of action under many of these laws, but there is, for example, California Invasion of Privacy Act. So then it's time to really defend what you've built. So next slide. So finding the right lawyer to advise at each step of the cycle really can be a challenge. And you will want someone at every step of the way who doesn't just know the law. They need to know your business. And those are two really different things. And they need to be at that intersection when they are advising you. So when you're thinking about finding the right lawyer, it's helpful to take into account a couple things. I mean, I think first and most basic is subject matter expertise and practice specific guidance. Evan will talk some more about this later in the presentation. But then it's also a question of where will you find that attorney who is best suited? Maybe your in-house counsel, if you have one, is there to, for example, connect the dots. That's where they're so valuable. And then translate between all of the business folks inside the company and outside counsel. For outside counsel, you know, do you go with a local regional firm? Do you go with big law firm like Cooley, maybe a boutique? Often when we advise, it's a team of all of the above, and everyone has different roles in this process. It often depends on where you are in that cycle. It depends on the specific product. It depends on who your customers are. The advantages, obviously, I'm biased, but the advantages of a bigger firm and contributing to that larger puzzle is that we do see the whole chessboard, right? We see trends, we see what's market because we don't see, you know, just a handful of contracts. We see hundreds and hundreds of contracts, and the same with financing documents from all across the country. And then we have a network of investors and advisors who can provide perspective that, along with our counsel, with your in-house team, gives you that complete picture so that you can make the best decisions. And with that, I'll turn it over to Evan.
Thanks, Naomi. Yeah, I want to reiterate that when I'm talking about how you could build a legal function in-house, why you should think about having a legal team, even if just the one lawyer in-house. I'm always talking about that as a team effort, like Naomi describes with outside counsel. I think that is, always going to be a part of the equation, because they are good at what they do, and there's a reason why they can charge what they charge. They really do add value to all of these processes. They are just perhaps not always the hammer for every nail, and I think that's what I'm looking to perhaps impress upon you here, is that you could reasonably ask, why do you need a legal department? Why do companies need to have their own lawyers? You start with outside lawyers, you like them, you keep using them, they seem really smart. Why would you think about eventually having somebody in-house who is essentially a captive lawyer, right? Like, this is why I got into in-house work, is that I like the idea of picking one client and sticking with them, right? And devoting all my energies to pulling on the same oars as everyone else in the company. Um, so I think the reason why you should think about needing a legal or having a legal department is about the most efficient ways to tackle all the risks we've talked about. It can seem daunting. It is pretty big universe of things you should at least be thinking about. So distilling that down into where should your company spend its limited resources, I think, again, is a team effort. And I think it can usually involve and should involve somebody in-house to do things in a little different manner than you would going to outside counsel. So I think of it as, how do you tackle, again, all the risks? And think about your own day. Like, how do you spend your time? Do you need to spend 100 minutes on one issue, or do you need to spend 10 minutes each on 10 different issues? And obviously both happen, but I'm questioning which happens more often. I'll suggest that I think you may be underweighting the latter. At least in my experience, a ton of the value add of an in-house counsel is those quick 10-minute interactions, whether it's Slack, used to be in person a lot more in the office, but it's quick meets and other things now. Those are some of the best conversations you have in this work, because you get a chance to nip things in the bud. If you can make it a 10-minute interaction, if you can make it a quick hit on Slack, you can make it something that your teams will actually engage with, rather than setting the bar high as, oh, okay, we need to have like a whole box in our project chart for like when this thing goes to legal, and that will take meetings and that will take weeks. And there's sometimes where that's absolutely required, where the decisions are important enough, where the implications are big enough for the product's own success or the company's success overall. Um, but it's not every decision. And sometimes managing these risks is about getting it right over and over again, and or getting at least like the least bad decision made repeatedly, because you're getting a lot of at bats here. You're selling to a lot of different school districts. You're selling to a lot of different parts of the country, basically. Um, and making sure that you have a consistent and efficient approach is just huge in terms of getting it done, and positioning your company for growth, proving that you can do this well. Not just that you built a good product, but that you can be successful in this space with these customers. So with that, I think I'll move into what kinds of things does an in-house lawyer do? I'm jumping ahead. I shamelessly stole these mission components from Amplify. It's how we thought about the legal department there for a long time. And I'll start with trusted advisor. And I've said, I think, that this is not just about, oh, is this one thing we want to do legal or illegal? Like, thinking about legal as a clearance department is, I think, too limited, but those conversations absolutely happen and are important. As I was just saying, those 10-minute check-ins where legal can be a helpful input into the company's decision-making processes across the board is key, and is really what you should frankly expect from an in-house legal team. I think we're also there to facilitate growth. So, and this is growth in terms of revenue and headcount and investment. And again, this is a lot about in particular, how you think about what future investors and other evaluators of your company are going to think. And it boils down to, in your Series B or your Series C, you are going to get more attention in the diligence process than you did in your seed round or your A round. And being ready for that is crucial. And so you need somebody, frankly, whose job it is to think about that kind of readiness. That is a big part of, I will say, the in-house counsel's role in a fundraising round, because the documents, we have outside counsel for that. They're great at it. They see the whole board. They've done a lot of fundraising rounds already this year. They understand what terms are market. That is not, you don't get the in-house counsel in that process to do the agreements for you. You have them so that you can set yourself up for the questions that are inevitably going to come from the investor council, from the people who have the money and want to give it to you, but want their lawyer to tell them that they're not making a stupid decision first. That's very important, and that is about doing the work ahead of time. That is not necessary. That is not always something that can be easily fixed, sort of after the fact, after these issues have already been raised in diligence. Next, we have protecting assets. And this, again, I think a lot of people will jump to the IP questions, and I think those are the meat of this for EdTech companies. Often a lot of what's valuable about your company is IP. I will say that you might be a little off in terms of how you weigh those different buckets of IP. I think my experience has been that that EdTech is not a particularly patent-heavy industry. So compared to startups and say like pharma, where basically the patents are the value of the company. There maybe sometimes is not actually a whole lot of daylight in between those two things. I think EdTech much more making use of all of the various rights that you can get through intellectual property. And in fact, often the thing you're doing is about how well your product accomplishes the goal, does the task, saves the teacher time, improves the outcomes for the students. And that is often about, frankly, how you designed it to work, which is, again, boiling it back down to IP, is often going to be about your copyright rights in the UI that you came up with, about the trademark rights in terms of how you consistently brand across different products and different features to create a cohesive platform. It is not always about a patent that you went out and got spent millions of dollars to get, and then are going to wave around and get other edtech companies to pay you for licensing that technology. I'm not saying that doesn't happen. I'm just saying that that is not the primary mode of value building in this industry, in my experience. And last, almost as a catch-all, we have solving problems, which again can seem kind of generic, but I think here I want to emphasize that Liu can sometimes be one of the few places in the company that has a very sort of neutral set of incentives. We're sort of trying to get everyone to solve this problem in the least bad way for the whole company. And I think sometimes that can be a good place to mediate some of the different incentives that'll come up between, say, the engineering team versus the sales team, who might obviously both want good things for the company, but their incentives are structured around how their, their KPIs, what they're doing and what they're accountable for, what they said is their OKR for this quarter and things like that. I think legal sitting in the middle and talking to everybody as some part of what they do can be really helpful in helping the executive team, who has a similarly broad perspective, drive towards the right decision for the whole company, not just for the sort of the team that's on the hot seat. Okay.
We have a couple of questions. Is this an okay time to take a couple of questions as we go?
Yeah, I'm happy to.
Great. So one is about how should early stage startups set and manage a budget for their legal expenses? Are there any benchmarks you would recommend for sort of a percentage of expenses to retain for legal, or a minimum number of billable hours that they should put aside to address risks?
I would say, from my perspective, at the early stages, that is a little hard. I mean, you should have a rainy day fund as much as you can keep one for bigger disputes or issues that might come up. I think the only way to build the plane of the legal department, though, overall, is by flying it. By which I mean, if you want to think about what it takes to get a bunch of customer agreements negotiated and done, I think you've got to try some and see if you can figure out ways to nip and tuck, see if you can sort of um, figure out ways to bill for that more efficiently. But for your company and your product with the early customers you've identified, I do think there's no substitute for sort of seeing what the first few ones cost you and sort of optimizing from there and projecting out from there. I wouldn't want to give you, oh, well, here's, what percentage of revenue it might be, because honestly, especially with school districts, there is not a sort of dollar to hour ratio that holds constant where school district spending $50 million will spend sort of 50 times more of your resources negotiating an agreement than a school district spending $1 million. If anything, it could be the opposite. You sometimes find large districts are sort of very sort of built up and ready to spend a large amount on something they understand and have standard forms for. Whereas a small district will give you a services contract that they clearly wrote to, like, get their basketball court paved, and except now they want to use it to buy a bunch of textbooks from you. And that happens, and that can actually take you more time in terms of man hours. So I wish I had a better benchmark for you, but like I said, I think you try flying the plane and build it out from there. I know, Naomi, you might have a broader lens on that. Anything to add?
Yeah, I mean, I guess I hate to say this, but it kind of depends. It kind of goes back to the question of specifically which part of the education ecosystem are you servicing, right? Because that can really dictate how complex and how much investment you need on the front end, and also specifically what your business model is, right? The way that you approach spend and investment, particularly in the build stage, depends a lot on whether you're doing direct to consumer versus selling into school districts, for example. So I hate to say it depends, but I think it really does.
Anything else you wanted us to tackle, Alex? Or should we move?
There's one more question, but let me Kashif, let's wait until the Q&A period, which I think is coming a little soon, and then you can come off mute and ask it directly. But please keep going.
Okay, well, we'll try to get through the remaining slides relatively quickly. This one, I just wanted to highlight some everyday tasks that this is kind of, if you have an in-house lawyer, this is what they're going to spend a chunk of their day doing. There is always, again, back to the trusted advisor role, if you guys are in the middle of a fundraising round or in the middle of a lawsuit, like, those things can obviously take priority and will swamp out some of these things. But these are the kinds of sort of everyday things that it's worth thinking about how to build good practices for. Because none of these things, negotiating a customer agreement, drafting an agreement with a vendor, putting an NDA in place, these should all potentially be easy. Any given counterparty can sometimes cause you some drama, but you should be able to think about doing each of these pretty quickly. What I want to make the pitch for is actually spending the efforts on building policies and practices here and processes, rather than just looking at everything as an issue of first impression, which can sometimes happen when you're dealing with, for instance, customer agreements. We are not in an industry where you get to always insist on using your own terms and conditions. I would say, roughly half your customers are going to insist on you reviewing the aforementioned basketball court paving contract, rather than looking at your terms. And so getting to consistency there, where you are incurring obligations that make sense for your organization, and you understand that, yes, we do this across all of our customers. We are willing to make this give. Or we are exposed to these risks because we always have to agree to this. Like Naomi was saying earlier, a lot of these customers will not agree to standard indemnity provisions. And so you have to make sure that your business team doesn't have it in their head that, oh, yeah, well, if they screw up, of course, they'll have to pay our legal costs. Like, no. And like, you can ask us to fight for it, but in many places, it is barred by statute and it's a non-starter. And you could burn a lot of time trying to fix that, trying to move them off the block. And it's much better to learn the lessons from the schools you do contract with, and again, try to build the most efficient process that still gets it right, that still leaves your company in a place where you understand the risks you're exposed to across all of these things. So I won't go into each of them because I do want to get time for questions. But I do just also want to touch on what are the sort of buckets that you might find an in-house lawyer prepared to do. And here, I think I've ordered them in the order I think you should consider bringing that work in-house. So these are the kinds you will see these terms attached to people's titles if you look at larger in-house legal departments. But I'm thinking functionally in terms of which things should you hire people to do, lawyers to do first. I think in our industry, commercial, meaning your customer contracts, makes a lot of sense. Your customers are strange beasts, for lack of a better term. They have these varying contract forms they want you to sign. And so you are selling to these bureaucracies and they vary widely in their complexity and their capacity. And so the contracts and other paperwork required to sell to Houston with 210,000 students are going to be very different from what's needed in, say, like Harvey, Illinois, with 1,000 students. You need to evolve the right practices to keep a constant risk profile across those customers. Corporate next is, I also think this is somebody who understands and frankly is responsible for your cap table and understands who owns the company and how that changes over various rounds of investment. When you set up equity incentive plan for your employees, you start granting stock options to people. Somebody really has to mind that store and be the ultimate source of truth for that. That is not the kind of thing that you can have too much uncertainty around. That will absolutely come up in diligence. Investors obviously will care about that. It will not end well if you don't know who owns your company. And there is just a lot of pieces to that that you might not appreciate until you have someone looking sort of through the pages. And this is something that outside counsel is, again, going to stay involved with. But I think there's a real value in having someone inside who can understand this stuff and help you strategize. Like, what kind of dilution can we look for in the next fundraising round? How should we think about that and help you model out, like, well, what will happen if we raise X? What happens if we raise 5X in terms of dollars? Like, how is that going to change how we think about the company and who controls it? Next is product counseling. And I have an example for this, which I will breeze through again in the interest of time. But this is, I think, somewhere where having lawyers who deeply understand what your product is, how it does what it does, and where it's going. Somebody who's embedded enough with the teams to understand what is the thing you're thinking about building, because they're there and they sit next to them, or at least virtually in Slack and elsewhere. That can be crucial for having, again, those efficient 10-minute hits where you get to guide the company towards a less risky place as the in-house lawyer, because someone felt like that you had an open door and they could come in and pick your brain about just the right way to think about a given product feature. Employment, IP litigation, these are all things where I think eventually it will be very useful to have in-house counsel for as you grow. But I think they are also areas where, in a lot of ways, you will know when you need a lawyer for it. If you get sued, it is obviously crucial to have good counsel representing you, but you will know to go call them because somebody will come to your door and serve you with a lawsuit. Like, it's not going to be a mystery. And so these are, in my view, areas where you need the resources badly, but you'll know there will be triggers for you to go ask outside counsel and get their expert assistance when those things happen. So I think those are lower down the stack in my mind for those reasons. So a quick example I want to talk about in terms of product counseling, because I don't know if everybody on the call will have a mental model of like what that actually entails. I think I picked one sort of off the pile of things to worry about. California's new age-appropriate design code. And this is really trying to figure out a way to address the bad experiences that teens are having online. And this one's interesting in that some parts of it were struck down, but some parts remain in effect. And so it has a laundry list of restrictions on tech companies, some of which have been, like I said, struck down because courts have an issue with them raising First Amendment problems, but some of which have thus far stayed. And so this is one example where it goes back to what Naomi was saying earlier about, does this apply? I think that is the first thing you want to think about. And so, for example, this regulation only applies if your product is likely to be accessed by children, which is a lot of y'all, I'm sure. But also, you have to have gross annual revenue of over 225 million, or the personal info of 100,000 or more consumers, or 50% of your annual revenue is coming from sharing consumers' info. Some of you may not be there yet. But what I want this to break out for you is that I think there's two questions. The question is, does this apply now? And then the next question is, when will this apply? I am guessing that all of you, if you have not yet hit $25 million in gross annual revenue, you have a projected plan for how you're going to get there. That's a goal. You want to do that someday, by and large. And so the question I'm trying to raise here is, do you have a process for checking in and knowing when your company will hit those thresholds? Like, that will be a milestone. Somebody will know it. You will obviously like tell your board that you got past this, but will you understand it's coming with enough lead time to figure out that, oh, that also trips us over into having this age appropriate design code apply to us, and therefore there's some compliance work we need to do. Remediation here is going to mean UX changes. Like, are you going to actually see that coming because you have product counsel who have thought about this regulation and have it as part of their job to make you ready for when the day comes that it applies? I'm mindful of the time, so I'm going to skip through the last couple. We're just talking about the ambiguity of the language and how it applies. Hopefully, it's pretty obvious that sometimes these statutes can be written with ambiguous language, and sometimes it can be hard to see whether or not your product is truly covered by this restriction, whether what you're doing in this example is, say, a dark pattern. And I'll just leave it at, this is a great moment of collaboration for outside counsel and in-house counsel. I would absolutely go and ask whether or not this applies to Naomi, and I'm sure Naomi would ask me, well, it depends on how your product works. Tell me a lot more about how this thing works. And I, as the in-house counsel, it's my job to understand, well, it works this way, but we're thinking about making a change in next quarter to work it this way. There's just a lot of communication that has to happen, and there's a lot of product knowledge you need to actually tackle this risk and know, wait, is this something I need to address? Is this something we are going to get in trouble for? Or can we make the right case that, no, it doesn't apply to us, no, this isn't a dark pattern, so on and so forth. So, sorry, with that, I am happy to jump straight to the Q&A and see what other questions we have that we can answer in the time remaining.
There was a really interesting question from Kashif. Do you want to come off mute, Kashif, and ask the question directly?
Happy to do that. Hey guys, hope you can hear me.
Yep.
Great presentation. One question, two different contexts. So early stage startup, when we're first engaging with, let's say, parents and learners, so that's context number one. Look, I mean, they are willing partners. The expectation is pretty clear that they're design partners in the workshop. They're kind of helping build the product alongside us, if you will. So what's the min bar, like, T's and C's that we got to have in place? Because long form contracts are not only premature, probably not realistic. And then the same question about the min bar T's and C's, but different context where for the prototype, we may be kind of like modifying or building on top of a curriculum that's available in the open realm. Like how far can we take that without breaking something? Thank you.
I'll start with the first. I think that there are a couple non-negotiables, and we see this every day. And I think if you are, it does depend on the product. Again, hate to say that, but it does kind of depend on exactly what you're talking about. But to me, the two kind of non-negotiables that you want to make sure you have is a feedback license and solid consents, particularly if minors are involved in the testing process. I don't think that it necessarily needs to be really complex, like, wet signatures, this whole, 15-page document. I mean, a lot of the pilot agreements or terms and conditions that we put into place are typically like 1 to 2 pages. It's pretty straightforward. And again, takes into account those two things. Again, it also depends on stage of the company, right? We will often help with product launches for multinational companies. In those cases, they're going to be more robust. For early stage startups, I think you do need something because you don't want there to be any question. First time you are fundraising, right? What is the question? First question that your investors are going to ask is, do you own all of this? And you want to be able to say yes with confidence, and here's why. So definitely feedback license, and then take into account any consents, particularly if you have children involved.
Yeah, and maybe I'll jump in with the second term there, where you're thinking about what can you build on top of. I think there's no substitute for reading the license there. I think, in the OER space in particular, where you looked at a lot of things that are available as open education resources, they have specific licenses. They will often use a Creative Commons license variant. Amplify's own K5 ELA curriculum, CKLA, is also available in certain forms under a Creative Commons attribution, share alike, non-commercial license. So like understanding what those prongs mean tells you whether or not you can build on top of CKLA, right? So if you are going to be willing to do attribution, that's usually table stakes. Every Creative Commons license requires it, but it's still an obligation. Like I was saying earlier, like you still got to track your obligations and know like, oh yeah, I do have to put attribution in the right places in the right part of my site. Then share alike is the viral version of a Creative Commons license, where if you're going to make derivative works of that original, then you've got to put your derivative out under a license that's no less restrictive. No more restrictive than that. So that's the thing you have to be comfortable with in terms of making sure that at least like the chunk you're building right now, that's a derivative on top of the original, are you comfortable with that being out there available for free? And then in the case of CKLA, you do have to satisfy yourself that you're not making a commercial use, because otherwise the rest of the open part of the license doesn't apply. And I think that is one place where, a lot of the startups on this call, like you guys might fall down on that requirement. You might have an issue. And that might be a situation where you might be very much within the intent of like what the authors thought they wanted to enable when they actually wrote it and made it available under this license. But you might just be like in a place where then you need to paper your commercial use. You might be able to go to the original rights holder and say, hey, technically I know what I'm doing is commercial and that I'm trying to make some money on this product, but I think it's something you would want done with your, like, this seems like exactly the kind of thing you had envisioned. Can you give us essentially a release and say that, like, despite the commercial aspect of this activity, where we are allowing you to use it under the license? It's a little tricky. I mean, I can't tell you you won't need somebody with some IP expertise to help you get that right release. But I do think it's worth doing for exactly the same reasons Naomi was just saying, that you're going to need to be able to show essentially good title to your product once it's built. And so those foundational things of getting the open source compliance right, if you're building on open source stuff, frankly, apply to code too. Like, we haven't even touched on what open source libraries your code is using, but that is often, you find, slightly more permissive licenses, fewer landmines in terms of what is going to go wrong if you don't talk to the right licensors. But yeah, I think the minimum in both cases, maybe the right way to think about this as a heuristic, is that idea of having good title to your product when you're done. When you have these third parties that contribute to it, will you be able to turn around and say, it's fine? They could turn around tomorrow and decide they hate what we're doing, but they can't break it by virtue of not having given us the right rights to make it. That makes sense.
Super helpful. Thank you.
Yeah. That was how many hundreds of dollars of free advice? Many. Wonderful. Well, thank you both so much for being here. I'm sure people have additional questions and thoughts, and they're transferring it to their own context. There's lots of dependencies here. But we wanted to thank everybody for being here today. Please, if you, I know we're a little late on this, but if you would scan this code and give us feedback, we are always looking for feedback from EdTech insiders about how to make these webinars more useful for the community. Please let us know how you're thinking, and we'd love to hear from you. And thanks everyone for being here. Evan and Naomi are both findable on LinkedIn. And of course, they're real experts in the field. Thank you so much, everyone, for being here with us at EdTech Insiders. This event was sponsored by Cooley and Tuck Advisors. And I'd like to thank Evan and Naomi. Do you want to have any last words for the group?
I'll just say thank you guys all for showing up, and I hope you found it helpful in the way you think about this. And it's really great to have the opportunity, after sort of being in the weeds with this stuff for 10 years, to give you some of my thoughts about how you can do things better than I did, maybe, and think about this stuff in a way that helps you guys succeed. Because I think I've looked at some of the products that you guys have from the attendee list, and there's a lot of things in there that I would love to see succeed. So don't let any of these risks be the reason you don't. There's the message.
Well put. How about you, Naomi? Any last words?
Likewise, couldn't have said it better.
Well, thank you all for being here. Look for an email with the link to the recording of this session, as well as summaries of some of the main points. Yeah, good luck with your legal journeys. And thank you both, the guests, again, for being here, and really appreciate it. Have a great rest
Thanks,
of your
everyone.
day, everyone.